Hi, my name is Steve Black, and I'd like to thank the organizers for inviting me to present today. If you have questions, please put them in the chat. From time to time, my first year law students ask me why they have to study property. And from time to time, when I'm speaking with a CEO or a CIO, they will ask me how they avoid getting sued following a breach. I'd like to give you one possible answer to both of these very serious questions. So it's an age-old story. Somebody breaks something, and then somebody suggests that there ought to be a law to fix it. Except in this case, everyone is rushing in to fix it. And if you were one of my law students, I would tell you that this is wonderful because more law means more work for lawyers. And the map that I'm showing right now tracks some of the many laws that we look at so that clients can, number one, comply with practices where they do business. And by that, I mean where they're collecting data from citizens. And number two, plan which countries they want to do business with or which countries they want to avoid. And number three, advocate with those governments for the types of laws that they want. And seriously, think about that. If more than 100 countries all try and pass laws, they're not going to agree 100%. And some of those countries will try and outdo others, and some won't really care, and it's a legal mess or a legal playground, depending on your point of view. On the other hand, if you're one of my clients, it really is a mess. How in the world, pun intended, do you comply with all of these laws? From Japan to Brazil to China to the US. And in the US, we've got many, many laws and many more coming as states see the impending railroad coming up. And so today's quotes that I'm going to show on the next slide are courtesy of The Princess Bride. And quite frankly, this is good advice when you're dealing with more than 120 countries all trying to regulate similar practices. So I actually do love legal history. It wasn't always the case, but I have found a new passion in it. So we're going to start back in 1753 with William Blackstone, who wrote that property is that relationship between a person and a thing, my pen. And then we're going to fast forward, right? That makes sense to a lot of us. We think about, I own this, or, I wish I owned that. We're talking about things primarily. And beginning in 1913, there was a shift. And Wesley Hofeld wrote that property is really relationships between people. And what he was talking about are rights and powers and privileges and immunities. For example, if I own a piece of land and you're trying to trespass, I have the right to exclude you, who has no right to be on the property. And then by 1961, we arrive at this understanding that property is a bundle of incidents. And we're going to talk some more about those incidents, but you can think about those as a bundle of rights. And what we're going to do with those rights is going to be very interesting. So if you can with me for just a moment, let's think about this. You've got a whole bunch of countries passing a whole bunch of data protection laws, and they give people rights to do things with their data or keep other people from doing things with their data. And that makes property, because now I've got the rights to the data and suddenly we've got property. Before this worldwide interest in data legislation, data was just data. Does it really have to be property? And I'm hearing my first year law students ask that question. So in 1986, a Mr. Lucas bought 2 lots in coastal South Carolina. And he was going to build single family homes on those contiguous parcels. At the time, there was no regulation to stop him from doing that. But 2 years later, in 1988, the state legislature enacted the Beachfront Management Act, which kept him from building any permanent structure on his properties. And he filed suit and said, hey, you know what? Even though that may have been a lawful exercise of state authority, You've ruined my vacation property, right? You've taken away all economic value. And he thought that that was a taking under the Fifth and 14th Amendments. And we're not going to go through the constitutional intricacies of this suit. But we will note that both Justice Scalia, writing for the majority, and Justice Blackmun, writing for himself in a dissent, said that, I mean, they used the phrase the bundle of rights. And Scalia said, understandings of our citizens regarding the content of and the state's power over the bundle of rights that they acquire when they obtain title is interesting to us. And so that's Lucas v. South Carolina Coastal Council, and that was a 1992 case. So we're looking at legislation creates rights, rights create property, even if we're not intending to necessarily create property. So if we're going to use these types of words, we probably ought to figure out what they mean. So some of the rights that we talk about, we'll start with the right to exclude, because that was in the Lucas case. One of the big things that the dissent was harping on was, yeah, but he still had the right to keep people off the property. So let's talk about what the right to exclude really means. With land, I can tell you to stay off or get off. Does that mean the same thing with data? So if it's property, I should be able to exclude others from my personal private information, but once they have it, what then? Both the CCPA and the GDPR give private individuals rights to exclude, but does that mean that I can make somebody forget what they saw? And that's a question yet to be decided. And this slide, I'm going to admit, is a little bit obtuse even for me. So Obi-Wan does the little Jedi trick, right? And the stormtroopers completely forget the question that they were asking. Does data work like a Jedi mind trick? Can I make people forget what they saw? Land is much easier. You know, if you're on my property, I can kick you off. So if exclusion or privacy is to have any real meaning for us, doesn't that require us to perform Jedi mind tricks? Or do we consider the right to exclude after the data has been seen to be completely illusory? Okay, so this slide actually has a different title. I mean, this is fine here, but I'm going to call this data is sticky. So I don't know if anyone has ever had one of these little sticky hands that, you know, they stick to the wall and stick to your sister and all kinds of other things. What do I mean by stickiness? So if I own a car and I want to sell it to you, once the sale is done, I don't retain any rights. And there's that word again. In your car, I can't walk over and say, hey, great car, I used to drive it. I'm just going to take it out for a spin again. We really frown on that in the law. But data is weird. Data is sticky. And again, this is my term, not any legislative, you know, action or whatever. So if you're going to use it in an article, you can cite to me. I'm perfectly okay with that. Section 1798.120 of the CCPA says this, quote, a consumer shall have the right at any time to direct a business that sells personal information about the consumer to third parties, not to sell the consumer's personal information. And just one more time for good measure so we can appreciate that. A consumer shall have the right at any time to direct a business that sells personal information about that consumer to third parties to not sell the consumer's personal information. If I sell a car, I give up all rights. I can transfer IP to you and mostly give up all rights. The mostly is in some countries, they recognize an artist's moral rights. And that really means that if an artist is creating a body of work and someone that they license the work to or sell the work to is using or misusing that IP to harm the artist's image or their reputation, then maybe they can, you know, claw it back. The US really doesn't subscribe to that theory, but we do have this data stickiness. And this legislative stickiness is fairly unique in the law, and it begs the question whether data can be sold at all. And we should talk about slicing and dicing. And we had a lot more time in this presentation, maybe even days. We could talk about how other types of property can get sliced into different pieces. So for example, if I own land, I could keep the land for 10 years and then give it to you. And we would each own the land, but at different points in time. Or we could do something different where I get 40% of the land and you get 60% now. So we're sharing it now. Or if we want to go into IP, I get to use the performance rights of the song that you own, but not the publication rights, and so on and so forth. And now that I think about it, some types of property are weird too. And property has a right of non-use or idleness. And what do I mean by that? So if I buy land or a car, I don't have to do anything with it. That birthday gift that your aunt bought you for your last birthday, you didn't really want and you still haven't opened the box, it's perfectly okay to keep it in the box. The property police are not going to make you use it. Data, can you really tell people not to touch it? And what does that mean? Once you've seen it, that's the use of the property. And now we're just getting warmed up. So data is a complex concept from a legal point of view. It represents information about a subject held by a collector, or information about a subject held by a collector that is now being processed by a processor. But both subject and collector and the processor have interest in the information. So we can talk about data mutuality. So for example, I have a social security number because the government made me get one. I have a driver's license for the same reason, and I have credit cards. All of those have numbers, and the question is, are those numbers mine, or the government's, or the bank's? And we may want to know the answer to that question because data equals privacy. So if we understand the concept of mutuality correctly, we would understand this quote from a 1960 case entitled Bradley v. Cowles, which said, "Guarantee of the right of privacy is not a guarantee of hermetic seclusion. We live in a society geared in the opposite direction, a society that makes public demands and imposes public duties." So in Bradley, the name and address of the mother of a 14-year-old who had been murdered was published in an interview with two of the men who were accused of committing the crime. Does a private citizen have rights in her privacy? And the Bradley case cited two other cases, and the first was Ike v. Perk Dog Food Company, which held that at least in Illinois, you can't take someone's photo for your own advertising campaign. And that's what the dog food company had done. They'd taken somebody's photo and used it without permission to promote a product. But Bradley also cited Anna Reno, in which a magazine ran a story that was entitled, "If You Love Me, Slip Me a Gun." And they printed the photo of a widow whose husband had been a police detective who was killed. And again, does a private citizen have rights? So strangely enough, these cases lead us to an interesting question. Who owns a paparazzi photograph? So before the current climate of rampant data regulation, we would have said the federal copyright statute said that the person who took the photo is the owner of the photo. Except in 2017, Khloe Kardashian was sued by Exposure Photos, a paparazzi site that took a picture of her with her sister. And Khloe reposted the picture, cropping out the copyright notice, and the two ended up settling. But a little bit later, Gigi Hadid, another international supermodel, had a similar conflict with the magazine. She posted one of the paparazzi photos that they had featured of herself on Instagram and cropped out the copyright notice. They sued her, and she said, "I didn't infringe on your copyright because it was a picture of me. And in fact, the only reason that it was an interesting picture of me is because of my body of work and because I'm so famous." So if anything, it was a collaborative process between the photographer and me. And we're back to this concept of data mutuality, which is, who really does own, something that we're fighting about here? That case was dismissed because Exclusive, the paparazzi company, didn't file a copyright registration. And so, we still have this issue out there of what do we do with photos that could be personal data at the same time they could be the subject of copyright. And as long as we're at it, let's talk about sharing information. So if you really want to know these things and you have some free time on your hands, September 9th is the most popular birthday. And according to one site that I looked at, Mary Smith is a name shared by just shy of 20,000 people. And California is our biggest state. So what? A lot of people have that information. As you begin to combine the information together, however, then we start to say, well, is this really identifying a particular person or persons? Do we share the data that we consider to be most private and personal? And as long as we're talking about sharing and people who aren't really interested in sharing, we have to go back to my poor 1L law students who ask me if they really do have to study property. And we have to talk about a couple of rules that may or may not have anything to do with data whatsoever, but are favorites of professors who like to torture students. And in the interest of not torturing you overtly today, I'm going to keep it really short. But the rule of capture usually starts with a case like Pearson v. Post, in which a couple of individuals decided, hey, it looks like a wonderful Saturday, so we're going to go out fox hunting. And that's with the hounds and the horses and the horns and, the idyllic British countryside, and off they go. And they find a hapless fox and they start chasing it. When lo and behold, out of the woods comes the other gentleman who happens to see the fox, takes the shot, kills the fox, and carries it off. At which point, the hunters on the horses say, wait a minute, that's our fox. And the gentleman with the gun says, really? Because I'm holding it and it's dead. And this is where the torture begins for law students. But it's an interesting case for us because it's data like a fox existing in the wild. The second rule that we really should talk about is the rule of finding. And you'll recall that we talked about property being relationships. So the question is, if I find something, I can have greater rights against some people who aren't finders, but lesser rights against people who are owners of property. And that boggles our mind how you can have more ownership in property depending on your relationship to the others who may have rights in that same property. What does that mean with data? Is it in the wild, undiscovered and ready to be captured? Is it lost and ready to be found? Did I abandon it? And do these old legal rules even make sense for us? So while we're asking these questions, maybe we ought to start figuring out what phrases we really need to become familiar with. Starting with, what do we mean by ownership? So John Locke wrote, quote, "He that encloses land and has a greater plenty of the conveniences of life from 10 acres than he could have from 100 acres left to nature may truly be said to give 90 acres to mankind." I am not sure about his math there. "For his labor now supplies him with provisions out of 10 acres, which were but the product of 100 lying in common." So the question we can ask is data like fallow land? Or if I collect it, is it mine? If I observe it, is it mine? If I derive it or combine it, is it mine? If I create it, is it mine? And all those questions may have the same infuriating answer, it depends. So we could assume, and I'm just going to pull some cases out here, and if you are interested, ask me in the chat or contact me via email later. I'd be happy to give you the sites to any of these. But if I create a theme song for you, or a logo, or a color, not many of us know that you can actually create a color and trademark it? Or a dance move? Is it mine or is it yours? In 1971, Carolyn Davidson was a graphic design student at Portland State. In 1969, 2 years earlier, she had met Phil Knight, the then assistant professor at Portland State, who would go on to found Blue Ribbon Sports and then a little company we know as Nike. Knight knew Davidson was in search of some extra funds, as all students tend to be. So he asked her to help him out on some projects at a rate of, wait for it, $2 an hour. Woohoo! So she charged him for 17 and a half hours of work and was paid by check of $35. He was staring down a deadline. He had shoe boxes in Mexico that really needed a logo and needed to be printed. He needed a decision. So he grabbed her rendering of the swoosh and said, quote, "I don't love it, but it will grow on me." True story. That starts us asking some of these questions. If we think about data mutuality, and if we think about others creating data or sharing data, who really owns it? Does your email address really belong to you? And by the way, Google, if you're listening, I have some other theories for you, and call me, right? You have my email address. Literally, you have my email address. Or on the other hand, if I happen to own the Twitter handle Real Donald Trump, does it belong to me? Or can it be shut down at any point in time? If you work for a company that does a lot of data collection, what do you do if the law says the data belongs to someone else? Hold on for 2 slides. We're going to get to the answer to that question. So some of the data protection laws refer to household data. That's an interesting concept. As long as we're creating new property out of nothing, what in the world is household data? And this is data that can identify individuals who live together in a household. And then my question is, so who owns that? What if I live in a household with children? You may recall that the law protects children and their data and their online presence. So can I consent to the use of data that is shared with children without implicating COPPA or any of the other children's data protection schemes? If that wasn't clear, for those of you who work for companies that collect data or who have apps that collect data, and you think, aha, we only sell to adults, so we don't need to worry about children's data protection schemes, you may be sadly mistaken. Once the law starts labeling things as household data, if there are children in the household, your life just got complicated. You're welcome. Some of you live in households with a significant other. What's hers is hers, so what's mine is hers, and if there's a question, it's hers. Can I consent to have someone use household data that I share? In the legal world, we would usually take a belt and suspenders approach to that. And so what we would do is make sure that everybody who possibly could own something signed off on our use of something. And as a data collector, what does that mean for you? That gets to be a thorny problem because, number one, your clients may not want to tell you if they have children or a significant other. And you may be thinking correctly in some instances that I really don't want to ask that question. And number three, you're thinking maybe the law is bad by even having shared data. And the question is, can we get around it? Because once we think about data as property, we start to think about data as shared property. And I have an address, and that can be a physical address, in which case all the persons who live here in my physical address share that piece of information. But I also have online addresses. And if I share those at any point in time, do they become shared data? And as a data collector, do I need to start thinking about my processes of data shariness? That's not a word, I just made it up. And for those of you who are thinking ahead, because that's the kind of person that you are, you're thinking about, hey, Professor Black, some of these data protection schemes require us to erase data. And how do I erase shared data? And my answer is, that's a really good question. This slide also has a funny subtitle, but just for me, which is robots are cool, but really should they be writing slogans? Or more to the point, if my robot slash AI slash whatever creates data, who owns it? Well, this slogan was actually written by AI. In the US, the copyright law usually says that if you create a creative work, copyright automatically attaches. To whom? To the creator. Who's the creator of AI-derived poems? If that's not interesting or scary enough for you, let me go a step further. So what if my driverless car, which for our purposes today, I'm going to name Frida, takes photos of all she sees around us with her 27 cameras? When she's not driving me around in her free time, she collates those into travel videos and uploads those to YouTube, where they go viral among all her followers who also happen to be driverless cars. I don't know who watches viral AI car videos, but somebody is going to. So she gets 10 million followers and YouTube starts sending her checks, which aren't really checks because seriously, how can my car cash her own checks, right? So they're auto-deposited. Okay, that's the dorky part of the humor, and I'm just going to stop. Auto-deposited. For those of you who are watching this later, you're going to pause here and think about what in the world is he talking about? Let me ask you a question. If that AI generated data starts generating money, whose money is it? As a tax attorney, can she claim me as a dependent? See, these are going to be really fascinating questions that are going to come up in your future. And this is what happens when you make data into property. So at this point, I'm going to refer back to how we started all this mess. Somebody breached a computer system and took data that didn't belong to them. However, the organization that owned the computer system didn't really own the data either. So what we're really doing is giving you, the data subject, some rights and privacy against someone who didn't steal your data, but who let somebody else steal your data. And you might ask me, why don't we just go after the thief? And I'm going to remind you that data thieves usually don't work in extradition jurisdictions. They typically work out of the non-extradition jurisdictions, or they flee to one, or in some cases, they are a non-extradition jurisdiction. And it's hard for us to punish countries. So we're left with you having rights against a company that did nothing wrong except they let somebody else steal your data. And now, let me see if I can answer some of the questions I promised at the beginning of this presentation to both my 1L property students and my CEO friend, and you too, Google. When legislatures begin regulating data, they quite unintentionally made data into a new form of property. We do that a lot. It's easier for us to take something unknown and to put it into a familiar box. And the process is familiar. We've been doing that with contracts and torts and know-how and all kinds of intangible things because property is a familiar box to us. Things have value, they can be transferred, and it's easy to have a quote owner. But data as property is weird, and we have a lot of weird property, especially when we consider intangibles. But data gets some unique properties, and people like me like to write about it, and judges like to struggle with it a bit, and we're off to the races. So is that the answer to the 1L question because it's interesting? Wait. With data as property, we now look at, and I'm not going to point anyone out, but Google and Amazon and Microsoft and the US Post Office and the Census and my favorite ukulele company, all of whom collect data. And we say, is that yours? And they might say, well, no, but look, it was running around the forest and wild and free, so I caught it and used it, like John Locke said I should. And is that going to be a problem? And that could be the end of the presentation, but it's not. Several years ago, I brought in a university tech transfer office to an entrepreneurship class I was teaching, and they told the class that all the information and all the data and quite frankly, all the intellectual property belongs to the university. And my students were horrified. And our client inventors were horrified. How can they claim that? They cried. What about the rights of inventors and freedom and privacy and all those other good things? And wait, I said, and watch the magic. Can the university market the IP? Do they want to? And how much is the royalty that they want? So if you have a very good friend with a very fast car, and the friend hands you the keys to the car and says, just be sure to bring it back with gas in the tank and maybe wash the windshield, are you happy that you don't own the car? So as a strategy matter, as we ask the question about who owns your data, we will still collect data and we will still use it. But we ought to be concerned with the law saying that's not really your data. And the way that we encourage our clients and our customers and others from whom we collect that data to trust us, so they will continue to hand us the keys to the very fast car. Thank you very much.